Hello everybody, welcome to EPG Pathshala. I'm Monica Sakhrani and we are going to look at women and law in 3 modules. We are looking at the first module now, law relating to domestic violence in India. So in this particular module we will look at the provisions under the Indian Penal Code and as well as the Protection of Women Against Domestic Violence Act. So these are the basic 2 provisions that are made, legal provisions that are made to address the issue of domestic violence, and we'll be looking at those. Now we know that in India around 1 in 3 women suffer from domestic violence, but what is more important is that very few of them actually take legal recourse, and there were no laws really addressing the issue of domestic violence earlier. There was a Dowry Prohibition Act of 1961, which basically was a toothless act because it made both giving and taking of dowry an offence, and the definition of dowry was such that it became almost impossible for you to prove, and even if you said that I gave dowry, you could go to jail for that. So it's a very less used law in India. Now, in the 1970s, there was this growing phenomena of bride burning or dowry deaths, because of which the women's groups got together and they started campaigning for a law which specifically addressed the issue of dowry death. Now, if a woman is killed by her husband, it amounts to murder. If a woman is beaten up by her husband, it amounts to causing hurt. But the thing is that what was happening was that many women were not able to take recourse to these laws. So the focus of this law reform was that there is very little evidence to show that this offence took place. Very often the woman is in the husband's house where she is killed. The witnesses are the family members of the husband or the neighbors of the husband who don't want to come and speak for the woman. So in these particular cases, how do you actually ensure that justice is done to the victim? So there was a campaign, a sustained campaign, and in 1983 the first set of laws specifically addressing the issue of domestic violence was brought in. So this and at that time the campaign was to bring in criminal law provisions. So section 498A was introduced in the Indian Penal Code, which made cruelty against a married woman an offence punishable with up to 3 years of imprisonment. Now this defined cruelty as 2 aspects. One is any willful conduct which is of such nature which is likely to drive a woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman. So this involved both physical and mental cruelty. And the second is harassment of the woman, where such harassment is with a view to coercing her or a person related to her to meet any unlawful demand for any property or valuable security, or on account of failure to do so. Now, so dowry harassment was just one of the aspects. It need not be an integral part of cruelty to a married woman. So it can be cruelty which is unrelated to dowry, or it can be pure dowry harassment. Both the cases are covered by 498A, and it is very important for us to know that, because very often women add dowry because they are advised to do so by lawyers, by the police, and when there is no dowry harassment, because they believe that that will make their case stronger. It need not make their case stronger. Cruelty itself per se, medical evidence is a very important part of it. So as a social worker, you should tell a woman that she should go and register NCs even if no FIR is registered, or she doesn't want the registration of an FIR every time the husband beats her up. It creates evidence. She should also go and get herself medically examined in a government hospital, because that is a public document and it can be used. No private doctor is going to come to the court and say that this is what this woman has been repeatedly coming to me because she's been beaten up by her husband. But if in a public hospital there are public records which and the doctors will come to court and give evidence, so we must advise a woman to do that. Generally, section 498A is used along with another section, which is section 406. 406 talks about punishment for criminal breach of trust. Now, what is criminal breach of trust? If a property is handed over to somebody in trust, Then when I ask for the property and the person refuses to give the property back to me, that amounts to criminal breach of trust. So I have voluntarily handed over my Stridhan articles, my jewelry which was given to me at the time of marriage to my mother-in-law, and my mother-in-law throws me out of the house without handing over the property. I have to say that yes, I asked for my valuables and it was not given to me. That amounts to criminal breach of trust. So generally what you call the dowry articles or Stridhan is woman's property, was generally seen as a civil wrong. If property is not given to you, go to a civil court and get your property back. So the police would not register an FIR under section 406. So there was this case called Pratibha Rani's case in 1985, where the woman argued that dowry articles or Stridhan articles which are in the possession of the mother-in-law or the husband, and when they refuse to hand it over, amounts to an offence of criminal breach of trust. And the Supreme Court accepted that argument, and they defined Stridhan as anything that is given to the woman by both her husband's family as well as her family at the time or during marriage, and any other property that belongs to her. So in Stridhan, the woman can claim more than only her dowry articles which are given by her side of the family to the husband's family. She can also claim whatever is given to her by the husband's side of the family. And so generally 498A and 406 are two sections which are added together in a FIR. Now, though both these sections are non-compoundable offences, the Supreme Court in a series of judgments has said that they can be quashed under section 482 if the parties have come to a mutual agreement to the case. So if suppose both the parties, the articles are returned back, and they both want to settle down, live together, there is a settlement, then the wife and the husband can move an application saying that we want to quash this proceeding. The court will quash it. Suppose they go in for a mutual consent divorce and they say that now each one is withdrawing all the cases against each other, there will be multiple cases, then in that case also the court will, in the interest of justice, quash the proceedings. The other provision which came in 1986, 3 years later. This is dowry death, which is an offence which was introduced under section 304B. Now, what is dowry death? Where the death of a woman is caused by any burns or bodily injury occurs otherwise than under the normal circumstances within 7 years of a marriage, and it is shown that there was harassment or cruelty with regard to demand for dowry, then the husband is deemed to have caused the dowry death of a woman. So what is required is that it should be an unnatural death, and it should be within 7 years of marriage, and that there should have been soon before her death harassment for dowry. So if the dowry harassment took place at the time of marriage and she died 6 years later, then that will not be held to be dowry death, because it was not soon before her death. It has to be soon before her death. That will amount to dowry death. In dowry death cases, there was an amendment made to the in the Indian Evidence Act. A section was inserted, section 113B, which said that if this happened, then the burden would be on the husband. The court will presume that the husband caused the death, and the burden will be on the husband to show that he did not cause the death. So if a woman dies under unnatural circumstances within 7 years of marriage, the husband has to show that he did not cause her death. Section 306, which was already there in the law books in the IPC, is regards to abetment of suicide. So suppose the husband tells the wife that why don't you just commit suicide, or I'll get you a matchstick, you burn yourself, things like that. That will be, or if you die, I'll be a happy man. All these things are instigation of committing suicide. So in abetment of suicide, what is required is that there should be instigation to someone to commit suicide, or being a part of a conspiracy to make a person committing suicide. So you make somebody's life so miserable that the person is driven to committing suicide, or intentionally helping someone commit suicide by doing an act or not doing something one is bound to do. So in these cases, it is an abetment of suicide. Now 113A was introduced to the Indian Evidence Act, which said again that if a woman commits suicide, so she may die, all unnatural deaths, a suicide is an unnatural death, but all unnatural deaths are not suicides. So if a woman commits suicide within 7 years of marriage and it is shown that her husband had subjected her to cruelty, in this case it is beyond dowry death. It is not just harassment for dowry. One of the drawbacks of 304B is that it sticks only to dowry. But if a woman commits suicide and there was cruelty by the husband, then it will be held by the court that the husband has abetted the suicide of the wife, or the relative of the husband has abetted the suicide of the wife, and then the burden shifts on the accused to prove otherwise. This is punishable with a maximum of 10 years imprisonment. 304B has a minimum of 7 years imprisonment. So these laws were brought in, and what happened over the years was that the conviction, though the crime has increased, the conviction rates are very low. And one of the allegations that started coming up was that women are misusing this law. Also, the thing is that if I'm thrown out of my house and my parents are not willing to keep me, basically what I want is some kind of sustenance if I'm dependent on my husband or my marriage. So I have no alternative but to actually go back to my husband and live in a violent atmosphere, or I commit suicide. If I file a criminal case, I really don't get anything, because criminal law is punitive in nature, it's not remedial in nature. So many women were also hesitant about filing criminal cases. If they filed the criminal cases, the marriage broke up, plus it led to a campaign that this law is being misused. So the women's group really started rethinking the strategy of how to address violence. And the West was looked at as a model. And what one found is that basically what women look for is some kind of civil remedies. So there was this, the civil law was drafted, Protection of Women from Domestic Violence Act, and a campaign was run around it, and finally in 2005 the act was passed and came into force in 2006. Now basically there are certain things in this particular law which one is it gives you civil reliefs. The second is it's a single window clearance system for women who are seeking legal redressal. And the most important, it applies not just to wives but all women in a domestic relationship. Now what is a domestic relationship? A domestic relationship is a relationship where a woman has lived in a shared household with a man, and she may be related to him either through blood or what is known as consanguinity, or marriage, or adoption, or in the relationship which is in the nature of marriage. So wives, mothers, sisters, daughters, any woman who lived in the shared household who is related in the extended family can file a case under this act. Also women who are in a relationship which is in the nature of marriage. The other is, what is a shared household? You should have lived together in a shared household. So shared household can mean any household where the two people are living together, irrespective of whether either of them owns the house or not. So it can be a house which is owned by my father. I'm living over there with by my father-in-law. I'm living there with my husband. It is owned by my brother, and I'm living in the house as along with my parents. So the house is in the brother's name, but I'm living over there. It's a shared household. That is a relationship with all the members in that family. So that is, so this act applies to all of them, and it basically recognizes the right of a woman to live in an atmosphere which is violence free. Now another interesting aspect of this law is how it defines domestic violence. So it basically talks about harm, injure or endanger the health, safety, life, limb, well-being, whether mental or physical, of the aggrieved woman, or tends to do so, and includes physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse, or harasses, harms, injures or endangers the aggrieved person with a view to coerce her or any other person related to her to meet an unlawful demand for dowry or property or valuable security, threatens the aggrieved person. Aggrieved person is the woman who will file the case or the victim, or any person related to her by any conduct mentioned in the above two clauses, or otherwise injures or causes harm, whether physical or mental, to the aggrieved person. So basically what this law looks at is 4 types of violence: physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse, which includes dowry harassment. So there are these categories of violence. For the first time, economic abuse, that is taking away a woman's freedom and throwing her out of the house, has been seen, or not giving her money for expenses. So if a husband is not maintaining a wife, that is also seen as violence. Sexual violence has been recognized very categorically. Examples are given, but it does not mean, if you read the DV Act and you see the example, even if it does not fall under any of the categories that are stated over there, but you can show that it is a type of physical violence, slapping, etc., may be there, but this may be a unique form of verbal abuse, unique form of emotional abuse, or economic abuse. You can bring it under that, you can file an application under that. So it just doesn't look at violence from the prototype of the way we look at violence, it's tried to look at it broadly. Now there are different authorities. This act does not rely only on the woman going to court. It's mainly there to protect a woman from violence. So there are 2 options open to her. One is non-legal options and the other is the legal option. So first we will look at, and the non-legal options will also, so there are authorities which are created under this act which will try to help a woman get out of the violent situation, and if necessary also help her, assist her in getting legal help, in going the legal way for getting this her rights. So the foremost authority appointed under this act is the protection officer. So the protection officer is a government servant or is appointed by the government, and in each district there should be at least one or multiple number of protection officers, and their job is to help the woman in accessing her rights. So one of the basic things they do is file what is known as a domestic incident report or a DIR. So they help the woman file a DIR. If she wants medical help, they have to get her medical help. If she needs a shelter home, then they get a shelter home. If she wants to go to the police, they take her to the police. And the domestic incident report, which is there as one of the forms attached to the DV Act, all these are available on the net. If you're handling any cases, please fill in a DIR. If you're a service provider or somebody, look at the DIR and familiarize yourself with it. It has details like the name of the woman, the name of the person who is causing her violence, the type of violence that she's caused, what kind of help she requires. So all this is written in the DIR. So the protection officer fills up the DIR, and if she wants to file a case, helps her in filing a case, in making an application before the magistrate. The protection officer also does what is known as home visits or a home visitation report. So also assists the magistrate in passing orders. So if the magistrate wants the protection officer to go and inquire into a case and give a report, then the protection officer does that. And in execution of any orders that the magistrate passes, the protection officer is supposed to help the woman in every way that is possible. So it's like a single window clearance for the woman. Now suppose the woman does not go to the protection officer, she goes to the service provider. The protection officer can also send her to a service provider. Who is a service provider? Service provider is a women's organization which is recognized by the government as a service provider. So there may be many NGOs, many women's organizations, grassroots level organizations. You may be working in an organization which works on violence against women, but at the same time there are certain, you have to ask for recognition as a service provider by the government. The government gives some money and grant to service providers. Now service providers have a different advantage as compared to other organizations that are working on violence, in the sense that they can file a DIR too. And a copy of the DIR, even the protection officer has to send a copy of the DIR to the police and the magistrate. The service provider has to send it to the protection officer. So every DIR that is filed by any authority apart from the protection officer, copy has to go to the protection officer and to the magistrate. So the service provider may provide certain services like shelter facilities or medical facilities to the woman, and also help her in filing the case. So even a service provider can file an application. Apart from that, the police are there. Suppose the woman lands up at the police station, the police file an FIR, or the woman doesn't want to file an FIR, then they have to inform her that you have a right under the DV Act. They can also file a DIR and refer the woman to a protection officer who will provide her with various services. Then there are medical facilities. Every medical facility has to provide medical services to the woman. They also have the power to write a DIR and forward it to the protection officer. Apart from that, there are two other services, counseling and welfare experts. These are generally used by the magistrates. If you go before the magistrate, if he feels that in the interest of justice, in the interest of the woman concerned, some counseling is required, he can send the woman to a counsellor. He can also take the help of a welfare expert who may also be a family member to settle the matter if he feels that it can be settled. So these are the provisions which are there under the DV Act. So once the procedure under the Act is that once the DIR is registered, this is supposed to be very much, it was envisaged as something similar to an FIR, but it has turned out to be very similar to an NC, in the sense it records the case. But what happens, and then the protection officer is supposed to record it, send it to the magistrate, and the magistrate is supposed to rely on the DIR to pass orders. But this is generally not being done. The other thing that the protection officer is supposed to do is prepare a safety plan for the woman. The safety plan also, the form is given in the Act itself. And the safety plan will talk about what is it that the woman is what is required to make a woman safe. And this has to be executed by the protection officer, but generally it's like a paper document. It's just written down and it's not really done, followed. Then of course the home visit reports are generally done under the orders of the magistrate. Now the way the Act is really panned out is that more and more women, they go to the protection officer, they go to the service providers, but they end up going to court. Many of them go directly to a lawyer and they end up going to court. So they file an application before the magistrate under section 12 of the Act. So that also, the application form is there in the Act, so anybody can draft it. You don't need to really go to a lawyer to draft an application. You can ask for what is known as interim reliefs. Under the Civil Procedure Code, a person is entitled to interim relief pending the final disposal of the case. There are timelines given, so within 60 days the entire case is supposed to be disposed of. But before that, within 3 days, an interim order has to be passed. It can be passed ex parte also, that is only after hearing one side of the case. So even before the man appears, the woman can be given ad interim relief, or ex parte orders can be granted. Now for interim relief, she has to file an affidavit. That is also given, the form is also given in the Act. Now once, generally what happens is that many of them, women go to the lawyer and the case is filed in the court, and then there is no DIR, so many times then the magistrate sends notice to the protection officer, calls the protection officer to the court, gets a DIR registered, gets a safety plan made, gets a home visit report done, and then takes the help of the, passes orders and takes the help of the protection officer in execution of the order. The police are also supposed to help the woman in getting the orders passed, in helping the protection officer in execution of the order. So suppose a woman has got an order saying that she'll go back to the house. So to go back to the house, the protection officer along with the police will take the woman back to the house to get her into the house or get her Stridhan articles back. So the protection officer along with the police have to help in the execution of the order of getting her Stridhan back. So this is the way the Act is actually panning out. Legal aid is supposed to be there, but most, so actually the protection officer can refer the matter to a legal aid lawyer. In many states, within the protection officer's office itself, a lawyer is there who is supposed to provide some kind of legal aid services to the woman. Now once the magistrate passes the order, does it mean that the order remains forever? It does not mean. Suppose even if it's a final order, it can be always altered, modified, revoked by order of the magistrate. Now in this particular case, either the husband or the wife will make the man or the woman will make an order. It need not be husband and wife. the respondent or the aggrieved woman will make an order application saying that now we do not need this order anymore, and it will be similarly altered or revoked or modified on the basis of that. Now suppose there is a breach of what is known as a protection order. We will look at what are protection orders by the respondent. Then the magistrate will take cognizance of this case. It's a non-bailable offence, it's a cognizable offence which is punishable with 1 year imprisonment or 20,000 fine. Similarly, if there is any breach of any of the orders, it will also amount to contempt of court. The burden of proof in these cases is that of a civil matter. It's a civil, even though it's tried by the magistrate's court, it is a civil remedy, we have to remember that. And the burden of proof is preponderance of probabilities and not beyond reasonable doubt. And appeal lies to the Sessions Court. Either party can go on appeal. Now, one of the things that the Act says is that the respondent is a man. So the cases started coming up. Many women started filing cases not just against their husbands but also against their mother-in-law and other family members, the mother's sister-in-law, etc. So the question came up is, can a woman be a respondent? This matter is finally, so earlier there was a judgment which said that a woman who's related to the aggrieved woman through marriage can be a respondent. That means a mother-in-law and a sister-in-law can be a respondent, but not my mother or my sister or my daughter-in-law. So now in this particular case, Hiral Harsora's case, the question came up because the case was filed by the mother against her son and daughter-in-law, saying that they are harassing. Now in this case, the matter was challenged, saying that you cannot file a case against the daughter-in-law. But finally the court held that a woman can be a respondent, and it can, a case can be filed against a woman respondent. There's no caveat against that. The second question, there are three questions which have been totally contested in DV Act. The second is, what is the relationship in the nature of marriage? Now in this particular case, what the court has held in several judgments is that relationship in the nature of marriage does not include all relationships or all live-in relationships. It includes only those relationships in which a marriage is possible. So there are two types of relationships which are covered under relationship in the nature of marriage. One is where both the parties are not married to each other, means the live-in partners are not married and they can get married. In those cases, it will be relationship in the nature of marriage. The second type of cases are where the woman gets into a relationship with a married man not knowing about his status. Apart from that, so if you knowingly get into a relationship with into a live-in relationship with a married man, you are not covered under the law. The other things that the court looked at is, do you have children? How do you portray yourself? Do you hold yourself out to be a couple? Do you have a public face? Is your relationship public or is it hidden? How do you share, expenses in a household? Do you have a joint account? Do you share expenses, or each one does their own thing? So in all these are other circumstances which will be taken into account in order to determine whether it is a relationship in the nature of marriage or not. This has been set to rest in Indra Sarma's case finally. So now many women who are in relationships which are not marriage but which are with married men, many of these women, the law was supposed to provide them with remedies, but now they are outside the scope of the Act. Now what are the reliefs that a woman can claim under this law? So the first relief is protection order. Protection order is an order which is telling a man to stop violence. So there are different types of orders which are specified under each of these categories, but you can ask for something which is not there also. So basically a protection order can be that a man should not beat up the woman, the aggrieved woman. The other could be that the respondent should not contact the woman in any way, the aggrieved woman, so not go to her place of work, not go to her place of residence, not contact her relatives, not come into the house where she is staying. So there are many such categories of offenses, of orders that can be got under protection order. As already stated in the previous slide, violation of a protection order is an offence and can lead to imprisonment up to 1 year imprisonment as well as fine. The second type of order that is got under this act is a residence order. A residence order basically would be that a woman should not be thrown out of the house, she shouldn't be allowed to live in the house, or she should be given an alternate accommodation, or she should be given rent. In Taruna Batra's case, this is the third contentious issue that I spoke about. In Taruna Batra's case, it was held, this was a house, shared household. The definition is it can be owned by anybody. The woman claimed to live in the house which was owned by her mother-in-law, and the mother-in-law said that she has no right to live in the house which is owned by her. She has to live where the husband is living. The husband was living in a rented house, and she claimed that she had a right to live in the house where she had earlier lived with her husband, and that was the shared household. In the Supreme Court held that where the house is not owned by the husband or the wife, it will not amount to shared household. So if the parties to the case are not don't own the premises, then it will not amount to shared household. So now many women who live in houses which belong to their in-laws have not been able to claim the right to live in the shared household because of this judgment. The third type of order that a woman can claim is monetary relief. Now, monetary relief can be maintenance. It could also amount to other kinds of monetary claims, such as medical expenses or any injuries that she's caused, loss of earnings due to violence. So all this will be covered under monetary relief. Monetary relief can be of two types, lump sum and monthly expenses. So you can claim both under the law, or you can claim either of the two. But you have to give the breakup of what your expenses are and then claim that in accordance. The fourth type of relief is custody order. If there is any child, then one can ask for custody. The fifth type of relief is compensation order. So compensation for violence undergone. So pain and suffering that a woman is caused, she can ask for compensation. It can be lump sum. The other kind of relief that she can ask for is return of Sridhan. So it need not be that she asks for only one of these reliefs. She can ask for all the types of reliefs or any one of them. And so these basically form the core of this act. So in this module, we have looked at criminal law relating to violence against women and civil law relating to violence against women. That is the Protection of Rights on Domestic Violence Act. You can look up the act, you can look at the forms, you can also read the e-text which is accompanying this PPT. Thank you very much.